And I want to thank everyone for joining us today. Unlike our normal What's New in Estate Planning seminar, we're putting this one on together today to go over what we call Mastering Your Trustee Duties. So this is a seminar about trust administration. And a big part of our world is not just setting up an estate plan, but also working with the trustee or executor on administering the estate. So this is where we, take a look at the documents, what are the assets, and then we work on settling the affairs. And this is sort of a very popular question we get is how does that actually work? Again, people know, who's in charge and where's the money supposed to go, but they don't always know how you get from A to B. And so we thought it'd be helpful to put on this presentation to make you think about how in your own estate plan, do you have the right person named? Is the plan going to work the way you want it to? And then this is really just an open forum so that if you have any questions about it, you can ask us. And so what we'll do is get started with the slides here. And of course, in general, we're giving very surface level general advice here. Anything specific that you have a question on or legal advice, ask your attorney. Okay. And Roberta, why don't you introduce yourself?
All right. So I'm Roberta Robinson and the founder of our law firm here, been in practice for 48 years. We're in Rancho Bernardo, California, and each of us is a certified specialist in estate planning, trust, and probate law. That is the area of law that we do. And I am the proud partner of attorney Daniel Wilson, who you see on the screen, and the grandmother of 5 wonderful grandchildren. Daniel, you want to introduce yourself?
Yeah. And I'm Daniel. Right, I've been in practice here for over 12 years. And of course, Roberta's my mother, and we have this hopefully a pretty good dynamic here that a lot of people like that if they come to us, they know that there's someone, younger that's going to be in the business for a long time, but also someone that has a lot of experience and have been in the community for pretty much the whole time for quite a while. And right, so I'm a certified specialist in estate planning and also have a Master of Laws in Taxation. And as far as the presentation goes today, so I'll be putting the slides and a handout into the chat. And if you have any questions during the presentation, you can also use the chat function to ask questions, and we'll try to answer them either during the presentation or at the end. Okay. So, what are we talking about today? Again, when we talk about administering a trust or an estate, really what that means is we are following the law, and in this case, the California Probate Code is the law that dictates how you administer an estate. And of course, the underlying document is typically going to be the trust. So there may be a will and a trust. So these are kind of the guiding principles when we administer an estate is what are the laws and what do the documents say?
Well, what are the first steps in taking over or planning to take over as a trustee? And we're talking about taking over as trustee for another person. This is not your trust for yourself. This is a trust for another person. It could be a spouse. It could be a brother or sister. It could be your parents. What is the situation in which you take over as trustee? So on this slide, you see 4 different scenarios of what could happen. Number one, let's say it's your parent. Your parent may decide it's time to add my child as a co-trustee. I know I'm getting quite a bit older. Maybe I'm in failing health. I'm worried about my ability to manage things. I'm going to amend my trust to add a child as a co-trustee. So that's one situation where you might take over. Another one is maybe the parent or the sibling says, I've had it, I'm going to resign. I know it's too much for me. And I'm actually going to sign a written document that I resign as trustee, and then the successor takes over. Well, those are 2 situations where it's been planned. But what if something sudden happens? What if there's an incapacity? What if someone has a stroke and they can't sign a resignation? They cannot sign an amendment. In that case, we have to look at the language of the trust. What happens if there's an incapacity? And trusts always say, well, if you get the letters of two physicians or one physician or my son John or a court order, it's variable exactly what it says, but we follow the terms of the trust to get that successor trustee into position. Finally, the last situation is when there's been a death. If the trustee has died, clearly the death certificate allows the successor trustee to take over. In the next slide, we have to determine which documents are you using. Let's say you are coming on board to take care of someone else's finances. In the estate plan, lots of times you'll see that there are two different sets of documents. There's the trust itself, and there's the power of attorney for finances. It's important to know which document controls which assets. The trust controls the assets that are in the trust. The power of attorney allows you to sign on assets that are not in the trust. You can't sign on the trust assets. So what would be not in the trust would be IRAs, maybe communications about Social Security, Medi-Cal, tax returns, utilities. So we always set up these two different kinds of documents in an estate plan, one to take care of trust assets, one to take care of assets that are not in the trust. Daniel, back to you.
Great. And when we are meeting with the successor trustee or the agent under the power of attorney, typically, kind of the first thing we talk about is what are your duties in executing the plan? And the trustee is held to what's called a fiduciary standard of care. And so they have to really, even though they're a lay person, so we say like a not a professional trustee, they have the highest standard of care and they have are held to the highest standard of care. So it doesn't matter if they make mistakes, they could still be held liable. And so, kind of, we're very cautious when working with trustees because our role is to make sure they follow the plan and that their risk of liability is reduced. So, the first thing we do is we review the documents. It's not uncommon that someone will come into the office and just say, I'm in charge. This is what the plan's going to be. This is where the assets are going to go. And I'm just going to make all these decisions. It's not really up to the trustee to make those decisions. They have to follow what do the documents say. So the first thing we do is we take a look at what is the will, what is the trust, and what does the power of attorney say as far as who's in charge and how do you become in charge, and then ultimately what's the plan of distribution for the assets. So we always want to make sure we're talking to the right person. So we look to see who's the trustee. Sometimes somebody might think they were the trustee, or maybe they were listed that initially, but these documents can change over time. And so anytime we have an existing client, we have all of your records of all the prior signed documents, and we know what are all the changes. Sometimes the family doesn't, or they might find just an old document and not think to look for a newer one and see that, oh, it looks like I was named as the trustee, but it turns out maybe that was changed a few years later. So that's the first thing we do is who is the trustee, who's in charge? And then, of course, we always want to know what is the distribution plan. So that's where after a death, we'll take a look to see within usually the trust, what is the plan of distribution? What's supposed to happen with the assets? And the best advice we can always give any trustee or fiduciary that's going to be administering a trust or an estate is to talk to an attorney because you don't know what you don't know. There's a lot of formalities in administering a trust, and that's what we're going to talk about today, are some of the formalities. And we hear all the time of experiences where once we talk with the trustee that we're going to be advising, they say, "Oh, my husband, he did this for his parents, and he didn't do any of these things. He didn't know he was supposed to follow these rules, and everyone just kind of got what they were entitled to." But we say, "Well, we're glad it worked out, but it doesn't always happen that way." So it's always best to speak with an attorney. And of course, the biggest deal after a death is we want to find out right away, is a probate necessary? Hopefully not. In a way, that's many times people's biggest reason for setting up their estate plan is simply to avoid probate. So if you were to pass away and you didn't have a trust or you didn't have your assets set up properly, the court would have to get involved to supervise the administration of your estate. So that's what we call going through probate. It's when the court has to oversee the administration process. And in California, it's really expensive to go through probate. It's one of the worst states to go through because it's so expensive and it takes so long. And so for every state has a version of probate. And again, California is just a very cumbersome one. And that's many reasons why we have typically everyone should have a trust as part of their estate plan, because that's the goal is to avoid probate. But mistakes happen even with your trust. Even if you have an estate plan, if you don't have your assets properly titled, you could still go through probate. So as an example, if I set up my trust today and I put my house and bank accounts and investment accounts, everything is retitled in the name of the trust, and then I die, probate doesn't get involved because everything is already directed to pass according to my trust. Or maybe I have beneficiaries on certain accounts. But mistakes happen. I go on living 20, 30 years. I bought another property. I opened up different accounts. I moved my investments from one company to another. And at the time of my death, if those assets aren't titled in the name of my trust, they have to go through probate. And so that's why we're always careful when we're advising clients while they're alive of making sure you have your assets properly titled and the right beneficiaries. But in the situation where you do have to go through probate, there's different levels of it. And so here we have kind of what we call our summary administration, which includes spousal property petitions, 850 petitions. Basically, when we talk about going through probate, most people are thinking about the big, long, expensive one that takes a long time and it's kind of a pain in the butt to do. But there are shorter versions of probate where if you can fit into these little categories, the facts have to line up right, that you can still go to court, so it's still going to probate, but you're not going through the whole big process. It's a summary, so it's just a one and done thing, meaning we submit a petition to the court. If the court agrees with what we're asking and saying essentially, this asset, it should have been part of the trust. Can you just show, or can you just allow us to transfer it into the trust without having to appoint an executor, notify creditors, and wait, months and months to close it? If the court approves it, then we can go ahead and just say, yes, this is an asset of the trust and get it transferred into the trust with a court order. So that is also something that an estate attorney would be aware of, that you can go through these shorter versions of probate.
So, where is the rule book? Now I'm a trustee. How am I supposed to know what the rules are? The rules are in the probate code, and the code enumerates all these duties that a trustee has. And we're going to take you through these duties to give you examples of what goes right and what goes wrong, because you don't need to memorize this yourself. You just have to become aware of the issues so that a light bulb goes off when you're the trustee. Uh-oh, can I do this? Do I need to ask first? Our first duty is the duty of loyalty. Who do you have to be loyal to? You have to be loyal to the beneficiaries. Well, who are the beneficiaries? Well, maybe my sister is going to get a share outright, but my brother who has financial problems, I'm supposed to protect his share for the rest of his lifetime. And maybe there's another share that's going to the children of my other deceased sister, and they have a long life ahead of them. So I can have beneficiaries who have different needs, and I'm supposed to be loyal and protect all of them. So you can see that I may intentionally or unintentionally breach my duty of loyalty. What are some examples? What if I sell a piece of property in a sweetheart deal to maybe one of the beneficiaries who says, oh, let's avoid closing costs, let's avoid commissions, I'll just buy it. Well, I have a duty to put that house on the market, get it broadly exposed to the entire market. I don't want to be hearing from other beneficiaries that it wasn't sold at fair market value. So these are just some examples of what might happen. Our next duty is the duty of impartiality. I cannot have a favorite beneficiary or a disfavored beneficiary. And what do we see sometimes? A child resents one of their siblings. My brother, he didn't work. Mom was always giving him money, on and on and on. You have to walk into the administration of the trust as unbiased as possible, as though you weren't even in your own family. and you have to take into consideration all of the people and not grudges that you may have that you're not going to give up. When you're the trustee, you've got to give up those grudges. What else could happen under impartiality? Let's say one of the beneficiaries comes to me and says, I know it's going to take many months until you're able to do a final distribution, but I need $10,000 right now. Well, if you think it's appropriate to give a preliminary distribution to that beneficiary, consider giving the same amount to each of the beneficiaries. The other beneficiaries are going to say, wait a minute, that person got $10,000 early. They had the use of that money for a long time. So to keep things impartial, consider doing equal preliminary distributions, if any. What else, impartiality? You may be administering a trust that says income is going to go to your brother for the rest of his life, and at his death, what remains goes to his children. So your brother's the income beneficiary, and his children get what remains. So they are the remainder beneficiaries. And you have a duty to both these different levels of beneficiaries. And your brother's going to say, you need to produce as much income for me as possible. I want lots of income. The remainder beneficiaries are going to say, you have a duty to build up the principal so that one day when we get it, there's still a substantial amount there. So there's this tension, you might say, between producing income and producing growth. And you have to pay attention to all of that. Another one, duties to avoid conflicts of interest. So here we have somebody lining their pockets with money. So it's hard to recognize when you're acting to your own benefit sometimes, especially for someone who hasn't done this before. The only thing the trustee should ever receive from the trust themselves is compensation. And that compensation is defined by the trust document. It might say reasonable compensation, and that would be what a professional trustee might charge, which might be maybe 1 to 2% a year, something like this, of the net value of the trust. It could be a dollar amount. The trust might say you are to be paid $20,000 and that's it, and that will be it. So we have to look at the trust. In any event, please keep a time diary of everything you do, the day you worked on the trust, how long, and what were you doing at the time. Because if it ever goes to court because somebody challenges it, the judge is going to say, show me that time diary and show me the hourly rate you put on the service you were providing. If you were cleaning the house, you can be paid as the house cleaner. If you were working with the CPA, you can be working maybe at the level of a bookkeeper. So it depends on what you are doing. Most importantly, you cannot borrow from the trust. And even if you say, but I wrote a note and I signed it back to the trust, you cannot borrow from the trust. And if you do borrow, whatever you use that money for, the beneficiaries can ultimately reach for the asset that you invested in because that was trust money. Also, you should not act as the realtor for the trust. You should use an outside realtor. Don't use your cousin. Don't use your best friend. Again, you want to look impartial and you did not act for your own benefit. Daniel, back to you.
Yeah, and the reason we say these things is we're always thinking, what if way down the line, the trustee is in front of the judge? Meaning, what if one of the beneficiaries gets upset and they sue you and they try to have you removed and they bring everything into court to show every single decision you made? You're in front of the judge, and now the judge is saying, how can you justify your fee? And you say, well, I just took, a flat dollar amount, or this felt right. The judges don't really like that. They don't want you to just go off a feeling. Same if you are benefiting from the trust because you are the trustee. Again, none of this looks good in front of the judge, and even being the realtor for the trust real estate. Again, imagine if there's a third party trustee, so it wasn't any of the kids or no beneficiary. It's just this third party that's acting as a trustee, and you're a beneficiary, and you see, oh, they're taking a trustee fee, they're taking commission from selling the property. I don't know who they sold it to. There can be a lot of distrust there. The same thing can happen again when you're the lay trustee and you're doing it among yourself and your siblings, is that none of these things look very good kind of looking back on it if a beneficiary is getting upset. And ultimately, of course, at the end of administering a trust, the goal is to distribute the assets. And then we always let the trustee know, by the way, you are still responsible and liable even after you distribute the assets, because eventually, when it comes time to do the distribution, and we'll talk about this later, there's a requirement that you provide an accounting record to the beneficiaries. So this is showing all of your actions as the trustee, meaning dealing with the assets. So you have your starting amount, you have any money that came in, any money that went out, income, expenses, realtor's commission, trustee fee. All of this goes on an accounting record. That's usually, again, when you send out the accounting, it'll start a period for somebody to object to your actions as the trustee. The period to object, it could be anywhere from 3 years down to 180 days. And so when we tell that to the trustees, they say, well, I don't like this potentially 3 years looming over me that somebody could sue me in the future. Can I just have them release me from liability and say that they're not going to sue me? And we say, yes, you can, but you cannot make that a condition for receiving the distribution, saying you can't say, I'm only going to give you the money if you release me from liability. It's specifically highlighted in the probate code to say you cannot do that. And so, what can you do to sort of reduce the risk? One, we can ask that they sign this release and discharge. Again, it can be at the same time you do the distribution. So you can say, here's the money. Will you release me from liability or sign this, and which releases me from liability? You can always, maintain a reserve within the trust. So to say, there are going to be future expenses even after we do the distribution. I still have to file the taxes. Maybe there's like little legal fees or mailing costs. So I'll have a little bit of money in the trust to cover those things. Well, if you're concerned about liability and you wanted to have a really sufficient fund to cover maybe potential legal expenses, you can hold on to that within the trust, even after doing kind of the big distribution. And then ultimately, oh, you can seek court approval. So hopefully the goal is to always stay out of court because it's expensive and it just takes a long time for the court to do anything. But you can, as a trustee, go to court for approval of your actions. So this is where you show the court everything that you did from day one to the date that you submit the court petition. You give a report of everything you did, including an accounting record. And if once you submit this to the court, you get a hearing date, you give notice to all the parties to the trust, so all the beneficiaries would know that you're doing this. If they wanted to object to what you're asking the court to do, which is approve your actions, they can file something in court or show up. If they don't object to it and the court approves it, that really does protect the trustee from any future objections or litigation from a beneficiary because they had the opportunity to do something at the court hearing. And so it's a way to not have the potential 3 year, period kind of just hanging out there. Other duties as the trustee. And so, unfortunately, we always say whoever's the most responsible one in the family gets burdened with becoming the trustee. So they'll be the trustee for their parents, their spouse's parents, a friend's parents, the other people. They'll when you're the responsible one in the group, people are going to think of you to name you as the trustee. And so it could come up that you're the trustee with different interests, meaning there could be adverse trusts in that one trust says, all the assets are there to support maybe the surviving spouse, and then upon their death, it goes to the kids. And there could be these situations where there's like second marriages and blended families, and potentially the trustee could have an adverse interest to what's the purpose of the trust? Who is it meant to support? And then maybe when they pass away, does it go to someone else? And so there are these issues where you could be involved with more than one trust. And as a trustee, if you have an adverse interest, that could go against what would be your perceived duty of impartiality. And anytime that comes up, we'll talk to a trustee and say, should you continue to act as a trustee, or do you really want to act as a trustee over maybe both of these trusts? If not, no one has to act as a trustee. You can always decline to act, Or maybe if you were acting for a period of time, but you no longer want to do it, you can resign as the trustee. So that's also something to keep in mind is that if you're the trustee over more than one trust, are there adverse interests? And is it something that you should step back from? And another duty. So again, the trustees all have all these duties that we have to advise them of. And one of them is to control and preserve the trust property. One of the first things we talk about again when working with the trustee are what are the assets? And we think, does this make sense to hold on to these assets until they're distributed? So again, let's say the person who created the trust has passed away. Now the trustee comes in to see us. We give them a worksheet to work off of to come up with a list of assets and liabilities because we need to know what does the trust hold on to and how are they held? Is it titled in the name of the trust? Maybe are there beneficiaries designated? So like IRAs or 401ks or life insurance. Certain accounts may have beneficiaries named on them, but it's up to the trustee to control them, meaning get everything under their name. One of the first steps in administering a trust is to get a new tax ID number for the trust. Because while you're alive and you have your own revocable trust, even though you put your accounts into the trust, they're still registered under your social security number. But when you pass away and the trust becomes irrevocable, you can no longer have accounts open over a deceased person's social. So the trustee can apply for a tax ID number from the IRS, and either the attorney or the accountant typically will do that. And then you re-register all of the accounts to be under the new tax ID number, under the new trustee's name, but it all stays within the trust. And once the trustee has controlled the assets and have them under their name, they have a duty to preserve it. So if the trust is meant to distribute the assets in, a couple of months or a year or something like that, it's not really up to the trustee to try to, wheel and deal and try to invest and speculate and try to grow the trust as much as they can for that period of time, because that could create risk. Their goal is to really preserve what's there. Instead, maybe if it's a lifetime trust, and so now there's a trust for the benefit of a teenager, and they don't get it until they're 40 years old, and the trustee is going to be involved for many, many years. That's the situation where now the trustee has still a duty to preserve the assets, but it's a little bit different than just maybe like liquidating everything and holding on to cash because it's going to get distributed in a couple of months. They can do investments and things and try to, grow within reason. And typically that would be a great time that a trustee works with a financial planner or a financial advisor because they'll advise the trustee on, how much is there, what's the purpose of the trust, and how long is it meant to go on for, and what are maybe the cash needs of the beneficiary. So these are all kind of within the scope of the trustee's duties is to preserve the assets for those people. And of course, the big deal of getting things under the trustee's control is getting an idea of the value of everything. And initially, when you're administering a trust, the trustee has a duty to come up with, appraisals of real estate, whether it's going to be a realtor's opinion letter or a formal appraisal. Depending on the situation, they may, if the plan is to just sell the house, within a couple of months, generally whatever you sell it for from close to the date of death establishes the new value from the date of death. But there could also be, investments and things. So you would want to get the brokers to adjust or to give you what's called like a date of death valuation. And the real reason why it's so important to get these new values is it adjusts the income tax basis of those assets. And so we'll talk about that a little bit more. But part of the trustee's job is also to do the taxes properly. And it's important for the trustee to know that after the death of, the owner of the property, so you have real estate, investments, things that maybe have appreciation in them, that after you die, if you're the owner, you get a new income tax basis on those investments and assets. And it's important for the beneficiaries to know that, essentially, because if you are distributing the assets out to them, so you're distributing the house to someone, or you're distributing stock to someone out of the trust, it needs to come out with the new income tax basis. And so it's the trustee's job to establish that. And the biggest thing that we give advice now, especially with all the fires in LA that happened, is that it's really up to the trustee to maintain insurance on the assets. And the big one obviously would be the homeowner's insurance on real estate. And of course, being in Southern California, people know that it can be very difficult to maybe apply for new policies. And there's a lot of companies that are leaving California. But it is the trustee's job to maintain the insurance because what if it's my house, yeah, it's my insurance, it's in my trust, and then the house burns down, but I didn't have good insurance? I can't sue anyone because it was my responsibility to maintain insurance on my house. But when I die and now the trustee's in charge of it, and the plan is maybe to hold on to it for a year and then they're going to sell it, if then the house burns down and the insurance doesn't pay out, the beneficiaries could say, Trustee, you breached your duty. You didn't maintain the insurance on the property. You didn't preserve it. And so now we're going to sue you for the loss in the value to the trust because you didn't maintain adequate insurance. And so again, we're really advising trustees to work and make sure you get the right insurance on the property.
So
Uh,
let's talk about taxes now. We have a lot to talk about. Some trustees don't find this to be the most fun part about being a trustee, but you have to do it. And I always recommend that you do work with a CPA. It could be the decedent's CPA. It could be a CPA that you choose. The first return you're going to be working on is the decedent's last income tax return from the last time they filed to their date of death. It's still their individual income. So that is a Form 1040 and a 540, and it goes under that person's Social Security number. The next return you're going to work on is the trust income tax return, and that starts date of death forward. And a federal ID number will be obtained for the trust income tax return. All trust investments will be made under the federal ID number. And it's important to think about how trusts are taxed. So if there's income, the question is it going to be taxed to the trust or is it going to be taxed to the beneficiary? Well, who cares? I'll tell you who cares. A beneficiary is in the highest income tax bracket when they have around $600,000 worth of income. But the trust is in the highest income tax bracket with just over $15,000 worth of income. So most trustees give serious consideration to how do I distribute income from the trust to get it to the beneficiary on time so that the trust is not taxed on that income. The trust shows it came in, it takes a deduction for distributing it out, and then it goes on the beneficiary's return. So it's very important before the end of the year, whatever the trust's income tax year is, maybe 3 months before the end, meet with the CPA to calculate how much income is in the trust and has any of it already been distributed? How do we distribute what is there? If there's a probate estate, that has its own income tax return. And it's the same Form 1041 and 541 as the trust return, but it's filed for the probate estate, which works under its own ID number. And again, if you've avoided probate, that's great. You've avoided another set of income tax returns. Now, that was income tax. What about some other taxes? There is the federal estate and gift tax. And I'm sure if you're attending our seminar here, you are probably aware of the fact that now you can leave $15 million tax-free at death. You can give $15 million away in your lifetime free of gift taxes. You can't do both. It's a unified system. So if you use part of it for gifts, then you've eaten up part of it that would be available at death. But $15 million per person is a big number. And if you're married, that's two $15 million exemptions. Lots of people think, oh my gosh, this estate is under $15 million. I'm not going to file an estate tax return. It doesn't even apply to this estate. Well, hold your horses. There are certain elections that you might want to make on an estate tax return, even though it's not required to be filed because you're under $15 million. And what are those elections? One is if there's a surviving spouse, the surviving spouse can elect to get their deceased spouse's unused $15 million exemption transferred to them. It's fantastic. It's called portability. And you have to file the estate tax return and make that election. So many estates did not file the return because they were under the big limit, the big exemption, that the IRS finally kind of caved in and said, you're normally supposed to make this election in 9 months after death. We're going to give you up to 5 years to make the election to grasp your deceased spouse's exemption. You want your exemption plus that person's exemption. And so if 5 years ago, that was 2021. So if you're a surviving spouse and your deceased spouse died around 2021, there is still time to make that election. It's something to look into. Other elections that you make on that return, even though it's not required to be filed, is something called a Q-tip election. And that causes a trust to be included in a surviving spouse's estate. And that might be done to get a new basis when the survivor dies, which we're going to talk about. All I want you to remember is right now, you might not be required to file the return, but you might want to file the return. And finally, this doesn't apply in every case. There's a generation skipping transfer tax election we call a GST election that can be made at the death of the first spouse, even though the return is not due, but it can be made on that estate tax return. So always check, should I file that federal estate tax return, especially if you're a surviving spouse? What about state estate tax returns? Well, in California, we have no estate or inheritance tax, so there's nothing to file here. But if you own real estate in another state, maybe the state of Washington, they do have an estate tax. And you have to concern yourself with should an estate tax return be filed in that state. So that's something your attorney and your CPA will look into. And now, the big area of property taxes. Here in California, I say that's the tax that keeps on giving. That is not a one-time tax. That is an every year tax on real estate. And we have some new rules having to do with property taxes. Daniel, do you want to go into the parent-child exclusion?
Oh, yeah. And so this is something that we talk about with pretty much every single client that we talk to. And it generates a lot of questions. So we understand that this could be its own seminar, webinar on its own, and we're just going over kind of the basics of it just to inform you and educate you that there's some things that need to be done when someone dies as it relates to property taxes. The biggest issue with property taxes at a death is are the property taxes going to be reassessed? So let's say between my spouse and I, we have our house and it's just in our trust, and I die, and she continues to own the house. Great. There's no property tax reassessment. When the real estate is going between spouses, it does not trigger any changes in the property taxes. However, if my spouse then dies and then leaves the house to the kids, there could be a change in the property taxes, meaning that essentially whatever the value of the property as of the date of death, the county assessor will come up with a number and say it's as if you bought the property for that amount. And again, in California, our property taxes under Prop 13, you get, 1% of the purchase price. So the property taxes would get reassessed up to that amount as of the date of death. And that will happen with my house, my rental income, commercial property, anything I own gets reassessed unless it qualifies under this parent-child exclusion. So under what we call Proposition 19 that was passed a couple of years ago now, there's a way to preserve the property tax bill when the property goes from a parent to a child, but it can only be on my primary residence. If it goes to a child and then they move into it and occupy it as their primary residence. So it's a very narrow exception. Again, if I have my house and maybe a rental property and a condo or these other things, even if one of the kids live in those other properties, I bought them all properties that they get to live in, but I'm the owner of it. When I die, all those other properties get reassessed for property tax purposes. The only exception, again, is on my home, my primary home, if a child moves into it and occupies it as their primary home. And there are deadlines, really strict deadlines of having to file certain forms with the county assessor within a year after the death of the parent. And unfortunately, there could be situations where if you go through probate or even in a trust, it could take more than a year to administer the estate. And sometimes you may not know who the property is going to go to, whether you're going to sell it or keep it, who's going to live there, is it going to be rented out. So these are some of the issues that it's helpful if are kind of raised very early on in the trust administration process. So you don't get too close to the year deadline and having to scramble and figure out what to do. Because even if it takes a year to figure out what's supposed to happen with the property taxes were reassessed back to the date of death. So it doesn't matter if you didn't file anything with the county, they weren't notified of the death. It doesn't matter if you haven't transferred the property out of the trust. The change of ownership date is the language that they use. When did the property change ownership? It's back to the date of death, no matter what. And then, of course, the next question we get is great. If the house does go to my child and they move into it, how long do they have to live there? It's only while they're living there that they can preserve the property taxes. So let's say I leave my house to my son, he moves in, it's his primary residence, he preserves the property taxes, he lives there for 5 years, and then he moves out and rents out the house. The property taxes go up when he moves out. So again, it's a very strict rule on this parent-child exclusion, and you're only able to preserve up to about $1 million above the current assessed value. So it's not uncommon that houses have appreciated more than $1 million since they were purchased. Again, many of our clients, you buy anything in Southern California, or especially maybe along the coast. Maybe you bought a house in Del Mar for $200,000, and now the parents have owned it for 60 years. It's now worth $5 million. So the assessed value is what they paid for it. So that's that 200. Maybe it's worth $5 million. Even in the situation where the child moves into the house after the parent passes away, they only get to exclude an extra million above the assessed value. So the assessed value goes from 200,000 to maybe 1.2 million. The difference between the assessed value and the fair market value is reassessed for property tax purposes. So even in the best case scenario, there still could be a change in the property tax bill. And again, it's something that we can talk about, while you're alive in your estate plan of maybe some planning around it. But again, after a death, it's very important that the trustee recognizes these issues so that we can hopefully preserve the property taxes to the best of their ability. Or if the plan is to sell the house, I mean, they know already the plan is to sell the house. No one's going to keep it. That's important for the trustee to understand that you are incurring a higher property tax bill every day, every month that you continue to own the property until it's sold. It's reassessed at the higher amount. And so if it takes even 6 months to sell the house, potentially the property taxes could have tripled or quadrupled for that 6 month period of time.
So what we've been talking about are expenses that could go up after a death. And in the big picture, we're talking about cash flow. So you can't think that everything's going to be the way it was when this person was alive. Things have changed. Property taxes may have gone up. Social Security may be lost. Pension income may stop. There may be a big federal estate tax due in 9 months on an estate over $15 million. So as the trustee, you're not going to wait till the last minute to figure this all out. From the beginning, you're going to look ahead 1 year, 2 years. What's going to happen? What kind of a budget do I have to plan on? Am I continuing to operate a business? Is something operating at a loss? What are the investments that I'm holding? And am I going to have a balanced budget, basically? And you want to foresee this ahead. It's not perfect, but as far ahead as you can possibly see. In our next slide, we talk about the possibility of having to sell the residence. Let's say I take over for a parent and they are running out of money, and now they have to move to a retirement facility that it's not feasible for them to remain in their home anymore. Uh, does it make sense to sell the residence to generate cash to take care of the parent? And lots of times we get a call from a child saying, I'm in the middle of escrow. I'm selling the house right now. And we say, whoa, we want to tell you about something that's very, very important. On the one hand, you may need the money from the house to support your parent. On the other hand, you have to think about the income tax consequences of selling the house. Let's go to the next slide and we'll take a look at what income tax consequences are. If the house is held until the parent's death, all the parent's capital gain will disappear because at a death, assets get a new income tax basis. So in Daniel's example, the $200,000 Del Mar house that has an income tax basis of 200, I know he was talking about property taxes and I'm talking about income taxes, but a $200,000 basis, $5 million is the current fair market value. That's huge, $4.8 million worth of gain. That's an extreme situation. But if that house is sold, what will happen? If the parent is alive, they will get the first $250,000 worth of gain tax free, but everything else will be subject to a capital gains tax. So that's millions and millions paying a capital gains tax. On the other hand, if the house is retained until the parent dies, the house gets a stepped up basis. All the capital gain goes away. And if the house is sold after death, right there, there would be no gain on sale. The money would come through tax free. So oftentimes children think, well, oh my gosh, what can I do? I need to produce more income. One solution would be to lease the property, move your parent out, turn it into a rental property, and rents here in San Diego are quite high, and you might get enough cash to support the parent. Another way is to sell a property, an option to sell after the parent has died. So there are all kinds of things to think about. And in this slide, we take a look at the $1 million sale with only a $40,000 cost basis. Now there's 60,000 of gain, but if it's sold after death, the gain disappears. Some other things to think about in selling a house: if the parent needs Medi-Cal or government benefits for long-term nursing care, they are allowed to own a house and still be eligible for these benefits. But if the house is sold, they need to spend down the proceeds of sale in order to become eligible. So the sale of a house during a parent's lifetime is basically a hot potato, and you need to review it with your attorney or your CPA. Daniel, back to you.
Okay. So as you can see, when somebody's acting as a trustee, whether the parent's alive or at death, again, not just the parent, kind of anyone, if they're alive or they've passed away, it's a lot of little decisions that can have big implications. And it's very important that the trustee is either aware of these implications or just gets advice. So many times a client will ask us, who should I name as my trustee? And we say, really, we just want somebody that's good at making decisions. So a decision would be hiring the right realtor or accountant or attorney, or the decision to sell the house at all. Again, the trustee is making all these decisions that will impact you, and some could have large tax implications. There could be tax savings. And again, it's a very important job that the trustee, obviously, other than being trustworthy, is just good at making decisions. Other duties that the trustee has is this, what we call this duty to make the trust property productive. And again, unfortunately, maybe sometimes where trustees get a little scared when they take over, and maybe they do want to just liquidate everything and just hold on to cash because they're so worried that if anything goes wrong, that they could be sued. And we say, well, if the period, the holding period, how long does it take to administer the trust is a relatively short period of time, that's reasonable because you need to, liquidate to pay the bills and then just distribute cash to everybody. But what if you have a plan, a trust that you're administering for many, many years? You could be considered breaching your fiduciary duty by just liquidating everything and sitting on cash because there's no income, there's no growth off of that. And again, the trustee has to keep that in mind when they're administering trusts that are meant to last a little bit longer. And a big eye opener sometimes when we're talking to our trustees is that they don't own the assets. The assets of the trust belong to the trust. The trustee is really just the signer on the trust. So they're allowed to make decisions and everything, but nothing really belongs to the trustee. And it's especially important when there's a lot of family relations. So where the trustee is like a child, and then there's beneficiaries or their siblings, that they can't just treat the trust assets as their own. And they especially cannot put the trust assets into their name personally. And again, we always highlight to the trustee, everything you own or everything that's in the trust stays under the trust, even though you're the signer on it, that you change the title of the accounts to stay within the trust, but you're the trustee. So again, if mom was the trustee because it was her trust while she was alive, and then she passed away, now it becomes the trust. The trust becomes irrevocable, and the successor trustee takes over. It also comes up where maybe the mom is alive and the successor maybe comes on board because mom's either incapacitated or is just starting to slow down and needs a little bit of extra help. It's not a good idea for the trustee to just get their name added on title to everything, maybe personally, where a lot of times maybe they'll say, "Oh, I just put everything into like a joint account so that I can sign on it and we can deal with paying bills and things like that." Like, well, that's helpful because now you can sign and pay bills and everything. But what if, the mom passes away? There's now this account that was joint, but when you have joint accounts, it just belongs to the survivor. And so if mom dies and now you are now considered the owner of the account, is that really something that was mom's intent? Did they want you to become the owner of those or not? And of course, in the trustee's job, they do have to, when they retitle everything, it can be frustrating to deal with some of these forms, and even though it might be easier just to put things in your name, but no, everything has to stay registered under the trust until it's time to distribute. And then we always will ask the trustee, are there concerns about any like liabilities to the trust? And of course, this is where there could be money that's owed to the trust. Commonly, how it comes up is again, mom and dad, they're alive, their assets, everything was in the trust, and maybe they were making loans to their children or helping support them, or maybe not a loan, but an advancement. And this is the situation where now the trustee, it's their duty to identify what is still owed to the trust or to the parents. And this is where it can get create a lot of conflict within the family if, one child says, "Oh, mom and dad gave me a gift of 50,000." And then the trustee says, "No, it wasn't a gift. It was like a loan. And obviously you weren't going to pay it back, so we're just going to take it off of your share of the trust." Who's to say? I mean, it's really up to the trustee to make that determination. But you can imagine situations where how far back are they going to go? Is it just what happened in the last year, or 5 years, or 10 years, or 20 years worth of gifts, loans, advances to the different children? Is that something that is all meant to be paid back? And of course, that can create conflict. And when we're working with our clients, if that is something that they talk about, is maybe adjusting the shares based on lifetime gifts, we can include that in the plan. And so the trust can say, either all the loans are forgiven, or it can say none of them are forgiven, or it can say, I will keep a record of any loans I make to my children, and then that will be used at the time of my death when deciding how to equalize the distribution. But it's sometimes, many times, there's not really that written record. And so it's the trustee's job to enforce and identify any of the money that should be owed or paid back to the trust.
Now we're going to talk about the duty to defend. And again, as soon as you take over as trustee, you want to look at the road ahead, a year, 2 years. Are there any actions that are going to be brought against this trust Are there any losses that we're anticipating? So what could that be? That could be a lawsuit. So we had a client that was the pilot of a plane that went down, very sad story, and had a passenger on the plane. So in that case, it was anticipated that the passenger would sue for the injury caused by the plane crash. Another client was in the middle of a divorce and died, and it was not finished. So it's not clear really what are the assets. And what happens is that the divorce proceeding continues after the client's death, so that finally it's divided. What are his assets? What are her assets? And you may wind up talking to various kinds of attorneys. In that airplane case, it would be a litigation attorney who deals with aviation. In the divorce, it would be a family law attorney. There could be real property issues, and you might be consulting with a real property lawyer. We have something that's allowed under the probate code, the notice to creditors. We always do that in probate, but even in non-probate, in a trust situation, we can publicize a notification to creditors in the newspaper that you must step forward within 120 days or your claim is barred. And if you really know of possible creditors, you must really deliver this notice to them themselves. So we always want to look ahead. In the next slide, we talk about the duty to supervise. And I always give the example of President Truman, who said, the buck stops here. On his desk, it said, the buck stops here. And what does that mean? It means that the head of the organization, which in this case is the trustee, is responsible for all the acts of the people whom they hire. So you might hire a CPA, you might hire a property manager, an accountant, a housekeeper, you name it. You are responsible for everything that they do or fail to do. So don't come up later and say, well, it's not my fault that they didn't do XYZ. It is always coming back to you. That's where the buck stops. So always keep a calendar and who is supposed to do what. It's almost like you're a project manager or younger people where they might have this spreadsheet that says, here's who's doing it. These are the dates that it's due. And if it hasn't been done, you've got to follow up with that person and see what's going on. So the squeaky wheel gets attention where you're demanding this has to be done, this has to be done. And importantly, this is a lesson in who do you pick as a trustee? It has to be somebody who has that toughness that they're going to take over, make demands, require excellent performance. They're going to complain if something isn't done right. They keep track of details. They keep track of time. They're good at calendaring it. So you know in your mind, this is eliminating a lot of people. It's a certain personality profile of who you should be picking to be the trustee. Now, here we have a brother and a sister, my, fictional family. The sister, it turns out, is taking care of everything, and the brother is playing video games. But they're both the co-trustees. So what happens? Even if the brother says, all right, I'll take care of the repair of the rental property, the sister is not alleviated from that responsibility. If he doesn't do it, she still could be liable if somebody falls on the property, the stairs collapsed, what have you. So each co-trustee is responsible for 100% of what is going on. So you have to think, do you want to be a co-trustee? Should one co-trustee step down? Lots of times children are appointed as co-trustees so that there is a checks and balances that they each know what is going on. They both have to co-sign for big transactions. So that is a serious thing. And many professional trustees, because there are professional trustees, there are corporate trustees, there are individual licensed professional trustees. They lots of times have second thoughts about ever acting together with another co-trustee, maybe a family member, because they become responsible for what that other co-trustee is doing. In the situation where there are co-trustees, often the law says the trustee fee, the compensation, will be divided equally between them. So that's another thought. Is that going to result in a fair outcome? And in our next slide, this is one of my fun slides. I've got twin brothers, and one is a highly educated doctor, and one is a far out musician. Not that I have any, bias either way, but what we have is someone who's very educated, who's expected to read contracts, who's expected to understand deadlines if he's in front of a judge. And the other brother, the judge is going to say, well, I can only keep him to the standard of care that maybe he's capable of. So the judge is actually going to hold him to a lower standard of care. So let's say, escrow's supposed to close on the sale of mom's house. And the doctor's been so busy that he hasn't signed all the documents and he needs more time. And now there's going to be extra expenses because of the delay. If this ever goes to court, the judge could say to the doctor, hey, you know better. You know what this means. You have to read these documents, sign them, get them back on time. And maybe the judge will say, I'm going to surcharge you. That means charge you personally for the damages resulting from this delay. And on the brother, he might say, yeah, I understand that you don't know what this is and you don't keep track of these things. And the judge might be a little, more soft on the brother who doesn't have the capacity. So the higher the standard of the education and responsibility that that trustee already has is how high the judge is going to hold them to a higher standard. Daniel, back to you.
Okay. And initially, when we're meeting with the trustee, one of the first things we have them get back to us with is, please give us all the names and addresses of the beneficiaries and heirs, because the trustee has this duty of notification. The trustee has to make sure that all the beneficiaries are reasonably informed of what's happening within the trust. And that's just the general term of the duty. Within that duty, there's very specific rules that the trustee has to follow, with the first one being this notification, meaning, again, while I'm alive, I have my trust, it's revocable, I can change it, I can do whatever I want, no one gets notified, it's a private document, no one else is going to see it. For the rest of my life, I can make as many updates as I want. But after I die, the trust becomes irrevocable. At that time, the successor trustee that's coming in, they now have a duty to send out this notice to all of my heirs and beneficiaries of the trust. And again, that's not always the same. If I have three children and I've included two of them and one of them I'm estranged from, so they're not included, they're omitted, that child is still my heir and they still have a right to this notification. So what does the notification say? Again, from the trustee, it says, there's this trust that was created. Either you're a beneficiary or you're an heir of the person who created it. I'm now the trustee because they've passed away. The trust is irrevocable. Here's my information. And then the main language within the trust says, now that you've received this notice, you have up to 120 days to contest the terms of the trust. Meaning, once the notice goes out, if a beneficiary or heir doesn't like what the trust says, they only have the 120 days to object to it. So essentially like filing a lawsuit in court. They have this kind of shorter period of time to do it. What goes out with the notification is what we recommend is sending a copy of the trust. So you would send out a copy of the trust along with the notice, and that starts the 120 days. If you don't send out a copy of the trust, the notice has to say, here's the notice, you have a right to request a copy. Once you make the request, you have like an extra 60 days. So we don't want people to think that the trustee is trying to hide anything from them by not sending out the trust or make it upon them to ask for the trust, because it also extends the period for them to object. So when we work with the trustee, we say, let's just get out the notice, send it a copy of the trust, everyone will see it, and then we have to wait the 120 days to see what happens. That 120 days cannot be waived. You can't consent to it. You can't say, to the beneficiaries here, here's this notice, but, just waive that 120-day requirement so we can get everything done. You can't do that. You really do have to wait. And typically, that is the period we say for the trustee to do the marshaling of the assets and preserving and getting everything under their control, because you have this 4 months before you're really making any distributions. Within that time, you can still pay bills, sell the house, file taxes. You can do whatever you need to within the trust. It's just the money doesn't go out to the beneficiaries until after the 120 days, is what we would highly recommend. And under a relatively new law, that requirement of sending out the notification absolutely has to happen upon death when the trust becomes irrevocable. The new law in California says if, for my trust, I'm alive, I have capacity, I can make changes to my revocable trust, but if I become incompetent and then I'm removed as the trustee, the successor comes in. Again, maybe they got those two doctors' letters to say I'm incapacitated. So when the successor trustee comes in, even though the trust is still revocable, I'm alive, it's still revocable, the law says, trustee, you have to send out a copy of the trust and the notice to all those same beneficiaries and heirs. So that could be something where a copy of the trust is circulated in my lifetime. In that specific case, you can opt out of it. So in my trust, I could say, even if I become incapacitated, I don't want my trustee to send out this notice to my heirs or beneficiaries. I don't want anyone seeing the trust until I pass away. So that has to be written into your trust, though. The default, if you don't opt out, is the trustee does have to send out this notice. Uh, Other ways the trustee has to keep the beneficiaries reasonably informed is with an accounting record. So one, if a beneficiary asks the trustee what's happening with the assets, how much is there, or what are the values of things, the trustee has a duty to respond. So any reasonable request for information, the trustee does have to be responsive to. Again, the trustee can't just say, I'm not going to tell you, you'll get what you get, and I'm going to, you'll get it all at the end. They can't do that. The trustee has to keep the beneficiaries reasonably informed, including if they ask about the assets. However, if that comes up, when we advise trustees, we say, again, it's just a snapshot on that day of what's happening. So if it's not necessarily a formal accounting to the penny to show this is everything that's been happening, if they ask for just what's happening today, you can tell them what's happening today. Eventually, though, there is a requirement to send out a formal accounting record, which would show from the date of death a list of all the assets and their values, a list of any income, so interest, dividends, rental income. If you sold something, you would have the gain or the loss. All of that, again, to the penny, is on this accounting record, all the way through any, again, distributions or expenses, including trustee's fee, attorney's fee, all of these things go on this accounting record. And then finally, what's left on hand at the end of the accounting period. So it could be from January 1st to December 31st. Again, this is what I started off with, and this is what's here today. So that accounting has to go out every year that the trust is in existence until it's terminated. So again, if I die and my trust is set up, to maybe pay out to my child for a few years until they're older, that child, as long as they're an adult, they get the annual accounting record until the trust is terminated. Once the trustee sends out the accounting, that starts another period for anyone to object to the trustee's actions. So that's where I mentioned earlier, it could be anywhere from 180 days to 3 years. It depends what the trust says. The trust could limit that period to the shortest as 180 days, but if the trust doesn't say that it's shortened, it is 3 years that somebody can contest what the trustee did for that period on the accounting. And again, this accounting would also show the trustee's fee. So there's actually a requirement by law that when you send out the accounting, there's things that have to go in like the cover letter, like you have to highlight certain expenses, including the trustee fee, if they paid a related party something. So if you paid your spouse to sell the house or clean up, or a sibling to do that, that has to be highlighted on the accounting record. So again, all that information does get disseminated to all the beneficiaries. And again, in our role, what we're trying to minimize the trustees, liability. And so typically, if we're sending out the accounting, one, if there's going to be a distribution plan that's part of it, saying we're going to be distributing these assets, we can have the beneficiaries consent to make sure that they know this is what they're getting, this is what everybody else is getting, and consent to that. Typically, there'll be like an language, like risk indemnification language in there. So eventually, again, the trustee has to, follow these duties to keep everyone informed about what's going on. And normally what we see, like a really good trustee, whether it's a professional or just, a lay person, just a regular person acting as a trustee, is the more communication they have with the beneficiaries, the better. So it's sometimes trustees will have like a monthly or even weekly kind of status report that they just circulate among all the beneficiaries saying, this is what we're working on now, and this is what we expect to happen. And then, we'll give you another update. Because anytime if the trustee is just, doing everything themselves and the beneficiaries don't know what's going on and it's up to them to start asking questions and keep bugging and bugging and bugging, that can breed a little distrust and, again, create a little friction and conflict. And again, another change in the law, so that requirement of doing the accounting absolutely has to be done. But even in that same example, if I'm alive, I'm incompetent, my successor trustee replaces me, they now have a duty to account to the beneficiaries of the trust. So even though I'm alive and the money's not going out to anyone other than me to support me for the rest of my life, the accounting has to go out to all the beneficiaries. And again, same thing, you may not like that. You may not want people knowing what's there, how's it being spent. Could one of your children say, why are you, to the trustee, why are you putting them up in such a nice living facility? Why don't you move them out to the desert and they can, save a little bit of money so that you're not spending down my inheritance? So those things come up. And again, if you don't like the idea of having these accountings being sent out in your lifetime, if your trust says, I don't want my trustee to do it while I'm alive, again, you can opt out of it. But the trust has to say that.
All right, you're the trustee for this delightful child, Mary. Mary wants more. When you look at the trust, you're going to see what your powers of distribution are. How much can you actually give to Mary? And in our makeup trust here, we're saying that you have a duty to preserve what's there for Mary's life. You have a duty to support Mary for the rest of her life. So you have to think, how much do I have here, and what can I really give her? Well, how am I going to invest this? And Mary's also going to come and say, give me money. So you're going to look inside the trust at your distribution paragraphs. And in this big trust that could be, 30, 40 pages long, you're looking for really maybe two paragraphs that say what you're supposed to distribute to Mary. On the one hand, it will talk about income. What are you supposed to do with the income from the trust? And that's going to be dividends, interest on bank accounts, rent, net rent from property. It's also going to say, what are you supposed to do with the principal of the trust? And the principal would be the actual investments, CDs, brokerage accounts, the real estate itself. You're going to see language that says you must distribute or you may distribute. So one is mandatory, one is discretionary. Some trusts say you must distribute the income to Mary, in which case from the accounting, which you're going to do or your CPA will do, you're going to figure out how much trust income is sitting there. And if I must distribute it to Mary, I'm actually going to be transferring it to Mary. If it says I may distribute it to Mary, lots of times it'll say for her reasonable health, education, maintenance, and support. Now you have to make a subjective decision. How much do you actually reasonably need to give Mary for those purposes, keeping in mind that this trust is supposed to last for the rest of her life? So you're going to be asking Mary, what is it that you need the money for? And we've heard interesting things come from beneficiaries. One beneficiary said, I need to build a new roof on a house that I own that does not belong to the trust. So the trustee is going to say, I can't give you money for a roof on your personal house. That's not for your health, education, maintenance, and support. We had another beneficiary who said, "You must buy me a home in Mexico, a vacation home." And again, the trustee looked at the language and decided it wasn't for reasonable health, education, maintenance, and support and had to say no. The trustee can say, "I can pay your rent. I can pay maybe for you to have a vacation, but I can't buy you a house in Mexico." So you have to look at that trust language and keep a written record of distributions. If you must distribute income, that quite easily is going to show up in the banking and accounting records. If you're going to fulfill a may distribute, you want to keep a written record saying on this day, according this paragraph, which says I may distribute for these purposes, I distributed to Mary this amount for this purpose, because later on it could be challenged by the remainder beneficiaries who gets what's left, or by Mary herself, believe it or not, if you use up all her trust assets. So you need a written record at the time. What was the decision that you made? And on the next slide, as trustee, you have a duty to be a prudent investor. Isn't that a term of art? What is a prudent investor? It would be how someone would invest the assets prudently, cautiously, with all the purposes in mind. It might be that I have to take care of Mary for life. It might be that I have to provide for somebody who has special needs. You have to take all these things into consideration. And the trustee will have a written investment policy every year. The trustee is going to write an investment policy and largely should have a financial advisor who they work with who can write the policy. And basically, it's going to talk about how much is generating income, how much is for growth. Even if it's for growth, maybe the plan is that part of it can be sold later to provide for the income beneficiary, but you want a written policy statement, and every year you revisit it and decide whether the assets of the trust should be reallocated, should they be diversified, and of course, they must be diversified. That is exactly what a judge is going to be looking at. If you're holding a big block of stock in Exxon because that is the stock that Dad had when he died because he worked for Exxon, the trustee actually has a duty to diversify that stock into various different holdings, unless sometimes they can get the consent of the beneficiary to not diversify. But diversification is the fundamental rule for trying to preserve the trust. The goal is not to make a killing in the stock market. It's to preserve what's there and be conservative. Daniel, back to you.
Now, after the trustee has been doing all of this work, should they, are they just doing it for fun? Well, normally the trust would say that the trustee can be compensated for their time or their services. But again, it is up to the trust to dictate what that fee would be. Again, when we're meeting with the trustee, the very first meeting of with the trustee is the most important one because we go over everything that they're supposed to do, everything that could go wrong, and then we really try to say, is this something you want to take on? Because it's a job, and even though you can resign in the future, it's typically once you start, you're going to be the person to finish it. And what we always go over with the trustee is what are the terms of the trust that say whether or not they can be compensated? Normally, the trust would just have the term that a trustee can charge reasonable compensation for their services. Again, this is now in the trustee's determination of what would be a reasonable fee. And it's not necessarily just what's their hourly rate. Again, if they're a doctor or a lawyer or or just anyone that has really high hourly rate, that doesn't mean that that's what they can charge the trust for their time. It's really what could you pay someone else to do the same thing for those services? And again, the trust has different levels of services. If the trustee decides I'm going to clean up the house, so I'm going to, go through all the items and figure out what's, to keep, what's to give away, what's to donate, the trustee is going to do it themselves, and that's hours and hours and hours of time. Really, what could you pay someone else to clean up the house? And maybe that would be what your reasonable fee would be for that time. Or if you're dealing with the accountant or the lawyer, maybe that's a higher hourly rate. Think all of these things kind of factor into what would be a reasonable fee for the trustee. And normally, when we're working with a trustee, we would say, again, in the first meeting, a lot of times they say they're not going to take a fee because, mom or dad wanted me to do it and it's just kind of the right thing to do. About a month later, they'll come back and say, okay, what was the fee I'm allowed to get? And they say, gosh, that's not even going to cover the headache that I've been dealing with. But because many people that haven't done it before don't really realize how much time is involved, especially if you have your own job, career, family, health issues that you're trying to deal with, or mom and dad's house, they lived there for 60 years and it's just full of stuff to the brim, and you can only get there like on the weekends to help kind of fix it up or clean it out and everything. That this is just something that you could be spending hundreds of hours on. And so we recommend, even if you don't think you're going to take a fee in the beginning, keep track of your time. So that's the diary, the time log, it's just like a business where you say, this is how many hours I worked on it, this is what I did, and then maybe this is my hourly rate for that service, and then you bill the trust accordingly. Many times a person will ask us, a client will say, well, what is a reasonable fee? And kind of the rule of thumb, again, it's not exact, but we always say it kind of expect it to be about 1% of the value of the trust per year. Potentially, this fee could be incurred in your lifetime. So again, I'm alive, it's my trust. I become incapacitated, my successor takes over. They are now acting as my trustee. They can start charging a fee for their services. I could be living for another 5 or 10 years while they are the trustee, and they're taking a fee on an annual basis every year. Or even again, upon my death and they're administering the trust, it could take a year or two, so they're taking a fee for all that time. And of course, it's important to know that if the trustee does decide to take a fee, it's taxable as income to them. So they would have to pay taxes on it. And again, it's just the best idea to keep a record of it because unfortunately, what happens at the end when you're, going to do the distribution among you and your siblings, if you highlight your fee again in that accounting record, you show what your fee is and it's taken off the top, and then you still get your, 1/3 of the trust. Even though you've done all the work, your siblings could still complain and say, why are you taking this fee? Why are you getting $10,000 or $20,000 just for doing this? Anyone could have done it. Again, people that haven't done it before have no idea what's involved. And so you do all the work and then you're still getting kind of bothered and people complaining about the fact they're even taking a fee, which sometimes if you did work it out to be hourly, if you really kept track of your time, it's, barely minimum wage. So again, it's just a great idea to keep track of that fee. And so that's really kind of all the trustee duties. And again, a lot of times people will come and say, I wish there was just like a book that you can put together to say exactly what needs to be done. The problem is every situation's different. The documents are different. There's 1,000 little decisions that will point you in a different direction. And so there's no real one comprehensive just advice to administer a trust. So that's kind of our role is to work with these trustees and advise them on these are the steps you take, as soon as someone dies and the timeline and the deadlines and everything and what the outcome's going to be. And everything is related to what do the documents say? What does the trust say? And then, of course, what are the trustees' duties? And if you are maybe a bit scared off of what we talked about of who you named in your documents to be the trustee, because some people say, "Oh, I'll just put, my oldest child," or we'll go oldest to youngest in order, and then, they'll just take care of it. It's making you rethink if anyone that you know is willing to do it. There are what are called professional fiduciaries that exist. So that's a person whose job it is to be a trustee. And so they're like certified by the state and licensed, insured, bonded, and that is their whole career is to be a trustee. And a lot of times they'll work with like a group. So there's maybe a group of people that work together. You still name them individually. They're all individually licensed. And of course, their job as the trustee only takes effect upon like your death or incapacity. So even though you're naming them in the documents, they don't charge a fee for their time. They're just kind of named in the documents and you could change it in the future. But it is helpful to know that sometimes, or if you're worried that even if you have the right people to do the job, it will just create conflict among the family, that just treat it like a job. So you hire someone to do it for you. So you could hire a professional trustee. And again, it's always a good idea that if you're acting as a trustee for someone else, that you're working really closely with an attorney to advise you, because again, you don't know what you don't know, and it's very easy to make mistakes, and sometimes it's hard to undo those mistakes after the fact. And we really want to thank everyone for staying with us for throughout this presentation. And it's something that we've done before, but it just generates a lot of interest. And we know that's sort of a blind spot for a lot of people when thinking about how their plan's going to work. They don't really think about the logistics of what happens after they pass away, other than I just want everything to go, again, 50-50 to my kids. But there's a lot to get it to that point. And of course, if you have any questions about this or anything related to your estate, you can always give us a call or email. And again, our offices are in Ranch Bernardo. And yeah, so we really appreciate everyone staying with us today. And I don't see that we've received any questions. A couple of questions might be coming in, so we'll try to answer them here. And you can put them in the Q&A. And again, otherwise, we really thank you all for joining us today. Okay, yeah. So the question talking about the slides, right? So I'll put the slides and the handout in the chat again. So if you logged on afterwards, that you'll be able to see it. And then also this meeting is being recorded. So afterwards, if you'll get an email with the recording, which will also include the handouts and the slides as well. Okay. One of the questions is, can you hire a professional trustee if I'm the trustee? So right. So in a way, let's say again in my trust, I name my son as the trustee, and maybe he steps in to take over it, but there's a lot of work involved and it's kind of, tough for him to do. He can't necessarily hire a trustee. He can hire people to advise him. So that's normally the estate attorney's role is for a lay trustee, is they would hire the attorney and then we kind of tell him exactly what needs to be done. And sometimes it's here's a letter of instructions that you need to do to execute, or there's more hand-holding and we have again like monthly meetings. But really it is the trustee's job to execute the plan. They could just hire people to advise them. Unless the trust says otherwise, the trust could say, if, again, my son doesn't want to do it, he can nominate a professional trustee. So you could always include that in your plan yourself, is to say, I want this person to do it, but if they can't, they can pick a professional to take care of it. And a very common question that comes up all the time is, yeah, what is the difference between a trustee and executor? I've been talking for a while, so Roberta, go ahead.
Well, the trustee manages the trust assets. The executor handles the probate estate assets. That might be the same person with two different hats, but that's the difference.
Yep. So again, it's pretty much the same person. So in your documents, you would have your will, your trust, and your power of attorney. Really, you're typically naming the same people in those roles to handle the finances, whether you pass away or incapacitated. And depending on what they're trying to do, they're just using a different document. So trustee and executor are very much used interchangeably. It's just, are they acting under your estate? So like if there was a probate, they would be the executor, or are they acting under the trust, in which case they'd be the trustee. And again, an issue that or a question that always comes up, or something we always talk about with clients, is not just what do the documents say, but how are your assets titled? So some things could be in the trust. Some things might have beneficiaries, like a designated beneficiary on a retirement plan, or life insurance, or there could be joint accounts. And depending on how those are titled, it determines what happens upon the death of the owner of those accounts. And right, some accounts may have what's called like a POD or TOD on the account, so payable on death or transfer on death. And so that's the designation that you set up specifically with that one account to say, this is where this account goes upon my death. And again, that supersedes what the trust says. So the trust can't control anything that's not part of the trust. So if you have a POD on an account, it just goes to whoever you named. Same with retirement plans, and that's a big issue that comes up quite a bit, especially a lot of people's retirement plans are a large portion of their estate. So they might have their house, then a retirement plans, of equal value. And the retirement plans pass according to the beneficiary that you designated on those accounts. And with some changes in the law in the last couple of years, the advice has changed of who should you name as a beneficiary. And so that's very important that you talk about who should be the beneficiary of these accounts with your estate attorney or even your financial advisor, because again, the laws change, and so that changes who should be the beneficiary. And a common question we get also is again for after you pass away, what if you do have like maybe a smaller account that's not in the name of the trust? So maybe just it's my checking account. I forgot to put it in the trust or I didn't want to do it. And it's, a couple of $1,000s and then I die. The trust doesn't automatically control those accounts, again, if it's not in the name of the trust or payable to the trust. So in those situations, if those accounts or assets that are in my name, no beneficiary, it just belongs to me, if that amounts to more than about $200,000, those do have to go through probate. If it's less than the $200,000, it doesn't have to go through probate. Whoever's in charge of administering the estate does have to deal with the banks and fill out a couple of extra forms, and there's like a 40-day waiting period to do it. But those accounts can get transferred into the trust after death without going through probate. And of course, a big question that comes up all the time is what if I move out of state? So it feels like there's quite a little bit of an exodus out of California. But if you have your estate plan, set up here while you're a resident, great. If you move out of state, we always recommend work or talk to an attorney in that state to review your plan. There may be very state-specific differences that would apply. So even though your plan might still be valid if you're a resident of another state, it may not be the best way to do it. Again, especially in California, with married couples, California is a community property state, and there's about 13, community property states, but there's many that are not community property states. So they may not necessarily have joint trusts like the way we do, or other states that, again, every state has probate. Every state you could go through probate. Some states don't typically use trusts because they don't need to avoid probate. It's not a big deal in other states to go through probate. If it's just California, it is a big deal. So that's why pretty much everyone has a trust as part of their estate plan to avoid probate. All right. So again, I think that wraps it up for the questions. If you still have anything, call or email, make an appointment at our office. And we really do appreciate everyone for joining us today. And hopefully we get to see you in person at some point. So thank you very much.